What is wrongful termination? Being terminated is never fun. It takes away your livelihood and puts a hole in your resume. Immediately after an employer says the words "you're fired," the employee automatically feels like screaming, "This is wrong." But when is termination actually wrongful in the eyes of the law? Many people think that if something is unfair, it is automatically wrongful. But while the words unfair and wrongful are synonyms, the phrase wrongful termination has a specific legal meaning, the purpose of which is to evaluate whether an employer's actions are illegal as opposed to unfair. In California, all employment is presumed to be at will. This means that either the employer or the employee may terminate employment at any time, with or without cause or prior notice. However, there are ways to defeat at-will employment. Employment is not presumed at will when there is an employment agreement or statutory or public policy exception to the contrary. An employee who is terminated before the expiration of his or her contract may have grounds to recover the full amount of that contract through a breach of contract claim. Most employment contracts define the specific reasons under which the employee may be terminated. This can be for a specified period of time or as part of a tiered disciplinary system. The employer is obligated to adhere to the terms of the agreement, and terminating an employee without following proper procedure may be a breach of contract. In some cases, the policies set forth in an employee handbook are a contract, so employers need to be sure to adhere to their established disciplinary systems. The public policy exception to at-will employment allows an employee to sue when the termination violates an important public policy. This means that the employee may sue an employer for wrongful termination if the employee was terminated for refusing to violate the law, performing a legal obligation, exercising a legal right, or reporting an alleged violation of the law to the government, law enforcement, or supervisor. The most common policies that support public policy wrongful termination suits include sexual harassment, whistleblower retaliation, and discrimination based on age, sex, disability, religion, race, and national origin. In other words, the law protects employees in a protected class or employees who are engaged in protected activity. California's protected classes are the largest in the nation. If termination arises because an employee is part of one of these protected classes, then the termination may be wrongful. It is not enough to be a member of a protected class. There must be a nexus between the termination and the discrimination. In order to establish a claim for retaliation, an employee must establish that he or she engaged in protected activity. There is no set definition of protected activity. The activities are set by statute and cover a wide range of issues. In recent years, one of the most commonly litigated issues involves whistleblower activity, where an employee is terminated for making complaints of what they reasonably believe to be unlawful activity. Not all termination is wrongful. However, if you've been terminated because of your protected activity or because you are part of a protected class, you should seek the advice of an attorney. If you are terminated without any prior disciplinary action, ask an attorney to review your employment agreement or employee handbook for a violation of policy.